Ch12, Restrictive Covenants 451. 4. What other types of covenants might offend public policy? And how far will public policy intrude on private ordering of property rights? Consider the following case. Shelley v. Kramer. 334 U.S. 1, 1948. Mr. Chief Justice Vinson delivered the opinion of the court. These cases present for our consideration questions relating to the validity of court enforcement of private agreements, generally described as restrictive covenants, which have as their purpose the exclusion of persons of designated race or color from the ownership or occupancy of real property. Basic constitutional issues of obvious importance have been raised. The first of these cases comes to this court on certiorari to the Supreme Court of Missouri. On February 16, 1911, 30 out of a total of 39 owners of property fronting both sides of Labadie Avenue between Taylor Avenue and Cora Avenue in the city of St. Louis, signed an agreement, which was subsequently recorded, providing in part, ******, the said property is hereby restricted to the use and occupancy for the term of 50 years from this date, so that it shall be a condition all the time and whether recited and referred to as, not in subsequent conveyances and shall attach to the land, as a condition precedent to the sale of the same, that hereafter no part of said property or any portion thereof shall be, for said term of 50 years, occupied by any person not of the Caucasian race, it being intended hereby to restrict the use of said property for said period of time against the occupancy as owners or tenants of any portion of said property for resident or other purpose by people of the Negro or Mongolian race. On August 11, 1945, pursuant to a contract of sale, petitioners Shelley, who are Negroes, for valuable consideration received from one Fitzgerald a warranty deed to the parcel in question. The trial court found that petitioners had no actual knowledge of the restrictive agreement at the time of the purchase. Property 452. On October 9, 1945, respondents, as owners of other property subject to the terms of the restrictive covenant, brought suit in Circuit Court of the City of St. Louis, praying that petitioners Shelley be restrained from taking possession of the property, and that judgment be entered divesting title out of petitioners Shelley and revesting title in the immediate grantor or in such other person as the court should direct. The trial court denied the requested relief on the ground that the restrictive agreement, upon which respondents based their action, had never become final and complete, because it was the intention of the parties to that agreement that it was not to become effective until signed by all property owners in the district, and signatures of all the owners had never been obtained. The Supreme Court of Missouri sitting en banc reversed and directed the trial court to grant the relief for which respondents had prayed. That court held the agreement effective and concluded that enforcement of its provisions violated no rights guaranteed to petitioners by the federal Constitution. At the time the court rendered its decision, petitioners were occupying the property in question. Petitioners have placed primary reliance on their contentions, first raised in the state courts, that judicial enforcement of the restrictive agreements in these cases has violated rights guaranteed to petitioners by the 14th Amendment of the Federal Constitution and acts of Congress passed pursuant to that amendment. Specifically, petitioners urge that they have been denied the equal protection of the laws, deprived of property without due process of law, and have been denied privileges and immunities of citizens of the United States. We pass to a consideration of those issues. I. Whether the Equal Protection Clause of the 14th Amendment inhibits judicial enforcement by state courts of restrictive covenants based on race or color is a Question which this court has not heretofore been called upon to consider. It should be observed that these covenants do not seek to proscribe any particular use of the affected properties. Use of the properties for residential occupancy, as such, is not forbidden. The restrictions of these agreements, rather, are directed toward a designated class of persons and seek to determine who may and who may not own or. Ch12, Restrictive Covenants 453. Make use of the properties for residential purposes. The excluded class is defined wholly in terms of race or color, simply that and nothing more. It cannot be doubted that among the civil rights intended to be protected from discriminatory state action by the 14th Amendment are the rights to acquire, enjoy, own and dispose of property. Equality in the enjoyment of property rights was regarded by the framers of that amendment as an essential precondition to the realization of other basic civil rights and liberties which the amendment was intended to guarantee. 7. Thus, 1978 of the revised statutes, derived from one of the Civil Rights Act of 1866 which was enacted by Congress while the 14th Amendment was also under consideration, provides. All citizens of the United States shall have the same right, in every state and territory, as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. 9. This court has given specific recognition to the same principle. It is likewise clear that restrictions on the right of occupancy of the sort sought to be created by the private agreements in these cases could not be squared with the requirements of the 14th Amendment if imposed by state statute or local ordinance. We do not understand respondents to urge the contrary. But the present cases do not involve action by state legislatures or city councils. Here the particular patterns of discrimination and the areas in which the restrictions are to operate, are determined, in the first instance, by the terms of agreements among private individuals. Participation of the state consists in the enforcement of the restrictions so defined. The crucial issue with which we are here confronted is whether this distinction removes these cases from the operation of the prohibitory provisions of the 14th Amendment. Since the decision of this court in the civil rights cases, 1883, 109 U.S. 3, 3S.ct 27 L.ed. 835, the principle has become firmly embedded in our constitutional law that the action inhibited by the first section of the 14th Amendment is only such action as may fairly be said to be that of the states. That amendment erects no shield against merely private conduct, however discriminatory or wrongful. Property 454. We conclude, therefore, that the restrictive agreements standing alone cannot be regarded as a violation of any rights guaranteed to petitioners by the 14th Amendment. So long as the purposes of those agreements are effectuated by voluntary adherence to their terms, it would appear clear that there has been no action by the state and the provisions of the amendment have not been violated. But here there was more. These are cases in which the purposes of the agreements were secured only by judicial enforcement by state courts of the restrictive terms of the agreements. The respondents urge that judicial enforcement of private agreements does not amount to state action, or, in any event, the participation of the state is so attenuated in character as not to amount to state action within the meaning of the 14th Amendment. Finally, it is suggested, even if the states in these cases may be deemed to have acted in the constitutional sense, their action did not deprive petitioners of rights guaranteed by the 14th Amendment. We move to a consideration of these matters. 3. We have no doubt that there has been state action in these cases in the full and complete sense of the phrase. The undisputed facts disclose that petitioners were willing purchasers of properties upon which they desired to establish homes. The owners of the properties were willing sellers, and contracts of sale were accordingly consummated. It is clear that but for the active intervention of the state courts, supported by the full panoply of state power, petitioners would have been free to occupy the properties in question without restraint. These are not cases, as has been suggested, in which the states have merely abstained from action, leaving private individuals free to impose such discriminations as they see fit. Rather, these are cases in which the states have made available to such individuals the full coercive power of government to deny to petitioners, on the grounds of race or color, the enjoyment of property rights in premises which petitioners are willing and financially able to acquire and which the grantors are willing to sell. The difference between judicial enforcement and non-enforcement of the restrictive covenants is the difference to petitioners between being denied rights of property available to other members of the community and being accorded full enjoyment of those rights on an equal footing. Ch12, Restrictive Covenants 455. The enforcement of the restrictive agreements by the state courts in these cases was directed pursuant to the common law policy of the states as formulated by those courts in earlier decisions. In the Missouri case, enforcement of the covenant was directed in the first instance by the highest court of the state. The judicial action in each case bears the clear and unmistakable imprimatur of the state. We have noted that previous decisions of this court have established the proposition that judicial action is not immunized from the operation of the 14th Amendment simply because it is taken pursuant to the state's common law policy. Nor is the amendment ineffective simply because the particular pattern of discrimination, which the state has enforced, was defined initially by the terms of a private agreement. State action, as that phrase is understood for the purposes of the 14th Amendment, refers to exertions of state power in all forms. And when the effect of that action is to deny rights subject to the protection of the 14th Amendment, it is the obligation of this court to enforce the constitutional commands. We hold that in granting judicial enforcement of the restrictive agreements in these cases, the states have denied petitioners the equal protection of the laws and that, therefore, the action of the state courts cannot stand. We have noted that freedom from discrimination by the states in the enjoyment of property rights was among the basic objectives sought to be effectuated by the framers of the 14th Amendment. That such discrimination has occurred in these cases is clear. Because of the race or color of these petitioners, they have been denied rights of ownership or occupancy enjoyed as a matter of course by other citizens of different race or color. The historical context in which the 14th Amendment became a part of the Constitution should not be forgotten. Whatever else the framers sought to achieve, it is clear that the matter of primary concern was the establishment of equality in the enjoyment of basic civil and political rights and the preservation of those rights from discriminatory action on the part of the states based on considerations of race or color. 75 years ago this court announced that the provisions of the amendment are to be construed with this fundamental purpose in mind. Upon full consideration, we have concluded that in these cases the states have acted to deny petitioners the equal protection of the laws guaranteed by the 14th Amendment. Having so decided, we find it unnecessary to consider whether property 456. Petitioners have also been deprived of property without due process of law or denied privileges and immunities of citizens of the United States. For the reasons stated, the judgment of the Supreme Court of Missouri and the judgment of the Supreme Court of Michigan must be reversed. Reversed. Mr. Justice Reed, Mr. Justice Jackson, and Mr. Justice Rutledge took no part in the consideration or decision of these cases. Notes and questions. 1. Racially restrictive covenants were widespread in the United States in the first half of the 20th century. See generally Michael Jones Correa, The Origins and Diffusion of Racial Restrictive Covenants, 115 Pol. Sci 541 Quetzales, 2001. Indeed, just 2 decades prior to its decision in Shelley, in the case of Corrigan v. Buckley, 271. U.S. 323, 1926, the Supreme Court had affirmed the enforcement of such a covenant, against the original covenanter, in the District of Columbia, on grounds that the Equal Protection Clause of the 14th Amendment was inapplicable to the federal government, a proposition the court retreated from in Bolling v. Sharp, 347 U.S. 497, 1954. Note that 3 justices recused themselves from consideration of Shelley. Justice John Paul Stevens, in his memoir, surmises that they had to do so because they owned homes burdened, and, in the view of many white Americans of the day, benefited by racially restrictive covenants. Justice John Paul Stevens, 5 Chiefs, a Supreme Court Memoir 69, 2011. 2. Does Shelley provide useful guidance on what types of privately agreed restrictions will be enforced and what types will go unenforced on constitutional or public policy grounds? Does the restatement do any better? 3. Like racism, racially restrictive covenants have not gone away. Though unenforceable in court, they remain in the chain of title of much residential real estate today. In the wake of white supremacist violence in Charlottesville, Virginia, in August of 2017, Charlottesville resident and legal commentator Dahlia Lithwick recounted. Ch12, Restrictive Covenants 457. Our lawyer once told us, when we purchased our home in Charlottesville, that the house to this day carries a racially restrictive covenant. No blacks, no Jews. That covenant is illegal and unenforceable. And so I have a house in Charlottesville that could once have been taken from me by the force of law. Dahlia Lithwick, They Will Not Replace Us, Slate, August 13, 2017. http://www.slate.com/articles/news_and_politics/politics/2017/08/Dahlia_Lee. Thwick_on_the_Nazis_in Charlottesville.html. Because they remain on the books, these types of discriminatory covenants still occasionally lead to disputes, particularly where residents continue to believe they are a good idea. See Nicholas Casey, Byers Rule in L.I. Town is relic of its Nazi past, N.Y. Times. October 20, 2015, at A1, available at https://nyti.ms/2ktuqew, Settlement. Agreement and Order, Long Island Housing Serves, Inc. v. German American Settlement League Incorporated, Case No. 15 CV 05987, EDNY January 13, 2016. Available at https://www.dropbox.com/s/6prg9wmf2sqy2/yafank.pdf. C. Modification and termination of covenants. Restrictive covenants, like easements, can be modified or terminated in many ways. The restatement mostly does not draw a distinction between these two types of servitudes with respect to modification or termination, meaning that the grounds for termination discussed in our unit on easements, merger, agreement, abandonment, etc. apply with equal force to restrictive covenants. One basis for modification or termination that is perhaps more likely to arise with respect to restrictive covenants than it is for easements is that conditions of the land have changed to such an extent that continued enforcement is inappropriate. This is particularly so where the restrictive covenants are part of a common scheme or plan for a community. In such a community, what types of changes to facts on the ground should justify terminating the covenants shaping the community's land uses? Property 458. LD Incorporated v. Town of Bethany Beach. 477 A.2 D 1066, Dell 1984. Herman, Chief Justice for the majority. This is an appeal from a permanent injunction granted by the Court of Chancery. Upon the petition of the plaintiffs, the Town of Bethany Beach, ETAL, prohibiting the defendant, LD Incorporated, LD, from selling alcoholic beverages at Holiday House, a restaurant in Bethany Beach owned and operated by LD. The pertinent facts are as follows. LD purchased the Holiday House in 1969. In December 1981, LD filed an application with the State Alcoholic Beverage Control Commission, the Commission, for a license to sell alcoholic beverages at the Holiday House. On April 15, 1982, finding public need and convenience, the Commission granted the Holiday House an on-premises license. The sale of alcoholic beverages at Holiday House began within 10 days of the Commission's approval. Plaintiffs subsequently filed suit to permanently enjoin the sale of alcoholic beverages under the license. On appeal, it is undisputed that the chain of title for the Holiday House lot included restrictive covenants prohibiting both the sale of alcoholic beverages on the property and non-residential construction. 2. The same restriction was placed on property in Bethany Beach as early as 1900 and 1901 when the area was first under development. As originally conceived, Bethany Beach was to be a quiet beach community. The site was selected at the end of the 19th century by the Christian Missionary Society of Washington, D.C. In 1900, the Bethany Beach Improvement Company, BBIC, was formed. The BBIC purchased lands, laid out a development and began selling. 2. The restrictive covenant stated. This covenant is made expressly subject to and upon the following conditions, viz., that no intoxicating liquors shall ever be sold on the said lot, that no other than dwelling or cottage shall be erected thereon, and but one to each lot, which must be of full size according to the said plan, a breach of which said conditions, or any of them, shall cause said lot to revert to and become again the property of the grantor, his heirs and assigns, and upon such breach of said conditions or restrictions, the same may be restrained or enjoined in equity by the grantor, his heirs or assigns, or by any co-lot owner in said plan or other party injured by such breach. Ch12, Restrictive Covenants 459. Lots. To ensure the quiet character of the community, the BBIC placed restrictive covenants on many plots, prohibiting the sale of alcohol and restricting construction to residential cottages. Of the original 180-acre development, however, approximately 1/3 was unrestricted. The town of Bethany Beach was officially incorporated in 1909. The municipal limits consisted of 750 acres including the original BBIC land, hereafter the original or Old Town, but expanded far beyond the 180-acre BBIC development. The expanded acreage of the newly incorporated town, combined with the unrestricted plots in the original town, left only 15% of the new town subject to the restrictive covenants. Despite the restriction prohibiting commercial building, no other than a dwelling or cottage shall be erected, commercial development began in the 1920s on property subject to the covenants. This development included numerous inns, restaurants, drugstores, a bank, motels, a town hall, shops selling various items, including food, clothing, gifts, and novelties, and other commercial businesses. Of the 34 commercial buildings presently within the town limits, 29 are located in the old town originally developed by BBIC. Today, Bethany Beach has a permanent population of some 330 residents. In the summer months the population increases to approximately 10,000 people within the corporate limits and to some 48,000 people within a 4-mile radius. In 1952, the town enacted a zoning ordinance which established a central commercial district designated C1 located in the Old Town section. Holiday House is located in this district. Since LD purchased Holiday House in 1969, patrons have been permitted to carry their own alcoholic beverages with them into the restaurant to consume with their meals. This brown bagging practice occurred at Holiday House prior to LD's ownership and at other restaurants in the town. LD applied for a license to sell liquor at Holiday House in response to the increased number of customers who were engaging in brown bagging and in the belief that the license would permit restaurant management to control excessive use of alcohol and use by minors. Prior to the time LD sought a license, alcoholic beverages had been and continue to be readily available for sale at nearby licensed establishments including, 1 restaurant 1/2. Property 460 mile outside the town limits, 3 restaurants within a 4-mile radius of the town, and a package store some 200 to 300 yards from the Holiday House. The trial court granted a stay pending the outcome of this appeal. 2. In granting plaintiff's motion for a permanent injunction, the Court of Chancery rejected defendant's argument that changed conditions in Bethany Beach rendered the restrictive covenants unreasonable and therefore unenforceable. The Chancery Court found that although the evidence showed a considerable growth since 1900 in both population and the number of buildings in Bethany Beach, the basic nature of Bethany Beach as a quiet, family-oriented resort has not changed. The court also found that there had been development of commercial activity since 1900, but that this activity is limited to a small area of Bethany Beach and consists mainly of activities for the convenience and patronage of the residents of Bethany Beach. The trial court also rejected defendant's contention that plaintiff's acquiescence and abandonment rendered the covenants unenforceable. In this connection, the court concluded that the practice of brown bagging was not a sale of alcoholic beverages, and that, therefore, any failure to enforce the restriction as against the practice did not constitute abandonment or waiver of the restriction. 3. We find that the trial court erred in holding that the change of conditions was insufficient to negate the restrictive covenant. A court will not enforce a restrictive covenant where a fundamental change has occurred in the intended character of the neighborhood that renders the benefits underlying imposition of the restrictions incapable of enjoyment. Review of all the facts and circumstances convinces us that the change, since 1901, in the character of that area of the Old Town section now zoned C1 is so substantial as to justify modification of the deed restriction. We need not determine a change in character of the entire restricted area in order to assess the continued applicability of the covenant to a portion thereof. Ch12, Restrictive Covenants 461. It is uncontradicted that one of the purposes underlying the covenant prohibiting the sale of intoxicating liquors was to maintain a quiet, residential atmosphere in the restricted area. Each of the additional covenants reinforces this objective, including the covenant restricting construction to residential dwellings. The covenants read as a whole evince an intention on the part of the grantor to maintain the residential seaside character of the community. But time has not left Bethany Beach the same community its grantors envisioned in 1901. The town has changed from a church-affiliated residential community to a summer resort visited annually by thousands of tourists. Nowhere is the resultant change in character more evident than in the C1 section of the Old Town. Plaintiffs argue that this is a relative change only and that there is sufficient evidence to support the trial court's findings that the residential character of the community has been maintained and that the covenants continue to benefit the other lot owners. We cannot agree. In 1909, the 180-acre restricted Old Town section became part of a 750-acre incorporated municipality. Even prior to the town's incorporation, the BBIC deeded out lots free of the restrictive covenants. After incorporation and partly due to the unrestricted lots deeded out by the BBIC, 85% of the land area within the town was not subject to the restrictions. Significantly, non-residential uses quickly appeared in the restricted area, and today the Old Town section contains almost all of the commercial businesses within the entire town. The change in conditions is also reflected in the town's decision in 1952 to zone restricted property, including the lot on which the Holiday House is located, specifically for commercial use. Although a change in zoning is not dispositive as against a private covenant, it is additional evidence of changed community conditions. Time has relaxed not only the strictly residential character of the area, but the pattern of alcohol use and consumption as well. The practice of brown bagging has continued unchallenged for at least 20 years at commercial establishments located on restricted property in the town. On appeal, plaintiffs rely on the trial court finding that the brown bagging practice is irrelevant as evidence of waiver, inasmuch as the practice does not involve the sale of intoxicating liquors prohibited by the covenant. We find the brown bagging practice evidence of a significant property 462 change in conditions in the community since its inception at the turn of the century. Such consumption of alcohol in public places is now generally tolerated by owners of similarly restricted lots. The license issued to the Holiday House establishment permits the LD management to better control the availability and consumption of intoxicating liquors on its premises. In view of both the ready availability of alcoholic beverages in the area surrounding the Holiday House and the long-tolerated and increasing use of brown bagging, enforcement of the restrictive covenant at this time would only serve to subvert the public interest in the control of the availability and consumption of alcoholic liquors. In view of the change in conditions in the C1 district of Bethany Beach, we find it unreasonable and inequitable now to enforce the restrictive covenant, to permit unlimited brown bagging but to prohibit licensed sales of alcoholic liquor, under the circumstances of this case, is inconsistent with any reasonable application of the restriction and contrary to public policy. We emphasize that our judgment is confined to the area of the Old Town section, Zone C1. The restrictions in the neighboring residential area are unaffected by the conclusion we reach herein. Reversed. Christie, Justice, with whom Moore, Justice, joins, dissenting. I respectfully disagree with the majority. I think the evidence supports the conclusion of the Chancellor, as finder of fact, that the basic nature of the community of Bethany Beach has not changed in such a way as to invalidate those restrictions which have continued to protect this community through the years as it has grown. Although some of the restrictions have been ignored and a portion of the community is now used for limited commercial purposes, the evidence shows that Bethany Beach remains a quiet, family-oriented resort where no liquor is sold. I think the conditions of the community are still consistent with the enforcement of a restrictive covenant forbidding the sale of intoxicating beverages. Ch12, Restrictive Covenants 463. In my opinion, the toleration of the practice of brown bagging does not constitute the abandonment of a long-standing restriction against the sale of alcoholic beverages. The restriction against sales has, in fact, remained intact for more than 80 years. And any violations thereof have been short-lived. The fact that alcoholic beverages may be purchased right outside the town is not inconsistent with my view that the quiet town atmosphere in this small area has not broken down, and that it can and should be preserved. Those who choose to buy land subject to the restrictions should be required to continue to abide by the restrictions. I think the only real beneficiaries of the failure of the courts to enforce the restrictions would be those who plan to benefit commercially. I also question the propriety of the issuance of a liquor license for the sale of liquor on property which is subject to a specific restrictive covenant against such sales. I think that restrictive covenants play a vital part in the preservation of neighborhood schemes all over the state, and that a much more complete breakdown of the neighborhood scheme should be required before a court declares that a restriction has become unenforceable. I would affirm the Chancellor. Notes and questions. 1. Several types of events may constitute changed conditions sufficient to at least trigger an inquiry whether a covenant ought still to be enforceable. Typical examples include condemnation of the burdened parcel through the power of eminent domain, typically bringing with it dedication to some purpose outside the scope of the covenant, zoning or rezoning, which may make the land incapable of legal use within the scope of the covenant, and nearby redevelopment that otherwise frustrates the purpose of the covenant. 2. The rule of LD would hold covenants unenforceable for changed conditions. If those conditions render the benefits underlying imposition of the restrictions incapable of enjoyment, do residents really derive no benefit from a limit on the available venues for the sale of alcoholic beverages in their family vacation town? Does anyone else derive a benefit from such limits? If property 464. So, are they the kind of benefits that are enforceable as a matter of the law of servitudes? 3. There are subtle differences in the framing of the test courts apply under the doctrine of changed conditions, particularly in the context of the covenants governing a common interest community. As the third restatement puts it, the test for finding changed conditions sufficient to warrant termination of reciprocal subdivision servitudes is often said to be whether there has been such a radical change in conditions since creation of the servitudes that perpetuation of the servitude would be of no substantial benefit to the dominant estate. However, the test is not whether the servitude retains value, but whether it can continue to serve the purposes for which it was created. Restatement 7.10, CMT. C. Do you think the difference between these two tests is likely to make a difference in the resolution of disputes? Which, if either, did the court apply in LD? If LD had applied the other test, would the outcome have been any different? 4. Does the mere fact of the disagreement between the majority and the dissent in LD have any implications for the soundness of the doctrine of changed conditions? If reasonable minds can differ as to whether a covenant can still serve its purpose or still provide some benefit to the dominant owner, might that in itself be a reason to continue enforcing the parties' private agreement? How does the answer to this question relate to the public policy limits on enforceability of restrictive covenants? On the danger of dead-hand control, discussed in the notes following Tulk v. Mahe.